Hello everyone. So I decided to be a good Samaritan and just help you guys out with your board exams. I will be helping you out with just getting 50%. We're trying to get 50% and that's it, right? So I've written this paper, so that's fine. So basically, paper one, what you'll need to know is just understanding the Constitution, the impact that the Constitution has in relation to court procedures. So your section 34 of the Constitution. I'm not going to go through the sources of law because that I would assume that you do know from your LLB. All right. Plaintiff and the defendant, that's your action proceeding. So the plaintiff will issue summons, but before plaintiff issues summons, we need to understand that there has to be a letter of demand that was sent before summons were issued. So this is for you to show that to show the court that you've made amends, to try and get the other party to take accountability and pay before you could actually institute this matter into court, right? So you have your plaintiff and your defendant. So your plaintiff will issue a summons. In the summons, there's two types of summons. There's a combined summons and there's a simple summons. So, which would, then there's also, let me not say two, let's say three, because then there's provisional summons. So these are three different types of summonses that you need to understand the differences. So, with your summons, think of action proceedings in a way where you play tennis. So you hit the ball, the other party has to hit the ball. So you issue your summons, other party will need to respond with the intention to defend. So now we've established that with action proceeding is more of a tennis ball. Think of it as if you're playing tennis, tennis court. So you issue your letter of demand that is done by the plaintiff. Then you give them time to respond. If they don't respond within specific time, then you issue your summons, right? So once you've issued your summons, then the defendant will then send in an intention to defend, stating that the intention to defend will have also it gives you as the plaintiff an idea as to who is the attorneys that will be that will be handling the matter of the defendant. So it actually gives you that as to who you send the correspondence to. And then the defendant will then either respond with the plea, they would respond with an exception, they will respond with the special plea, and they might also have a counterclaim. So when it comes to a special plea, there's ways of which they love this question actually. Because I've seen in the past papers when I was doing them quite a lot, they would raise a question on special pleas. So just understand the different types of special pleas that can be raised. Once those pleadings have been exchanged between parties, the matter can now be set down for pre-trial. So the pre-trial purpose is for both parties to be in a position where they actually state if the matter is ready to be taken to trial. So both parties have complied, the pleadings are ready to be closed. If there's going to be any witnesses that they'll be calling in, out-of-town witnesses. Also just discussing the common cause facts that will be addressed in the actual trial, and also if whether the issues will be combined or will the issue of merit be heard differently to the issue of the quantum, so liability and quantum, that's the way it is discussed in the pre-trial conference. And then that's when you apply for a date. So you go to the magistrate, so your matter is heard for pre-trial conference. You have a pre-trial conference before you have a pre-trial which is set down. So you set down, so the magistrate in this instance will then check, go through the file and see if the matter is ready to be heard for trial. So then you go and get a date for trial, and then both parties will appear in court for the trial with their witnesses, and yeah, you prepare for trial. So that is in relation to action proceeding. And then with application, remember I told you guys, we just trying to get 50 here. So we just need to understand the overall. So whatever question they pose it to you, you'll be able to answer. In application proceeding, this is done a bit differently. You're thinking about it as far. So there's a founding affidavit that is sent through by the, so now the parties here, we need to understand the parties here are a respondent. There's an application proceeding, applicant, and then there's a respondent. So you respond to the application. So what happens is that you do with your notice of motion, you will include your founding affidavit, which actually stipulates what is the matter about, and then the respondent will then respond with an intention, with the notice of intention to oppose. Remember, in application, in action, you had a notice of intention to defend. So now you have a letter, an intention to oppose. So if the application is opposed, then you will respond with a answering affidavit. So this is the respondent will also attach, so they'll send a letter of intention to oppose, and then later follow up with the answering affidavit. Remember, FAR, FAR. So we're still on the A right now. So now the applicant will then respond. So this is called a reply. So you reply to the respondent's answering affidavit, and then the matter is then set down for hearing. So this already the magistrate is able to, the magistrate or the judge is able to make a decision based on the papers before him, based on the affidavit presented to him in court. So you don't, there's no need for cross-examination or calling upon witnesses. The magistrates, if they feel that there needs to be supplemented, there's information missing and they can't make a decision on the matter based on the paper, the magistrate will ask the attorneys, the legal officials, to actually supplement their papers, or maybe also ask for them to have like confirmatory affidavit for people that are cited in the affidavits. And if so, still the magistrate is unable to, the presiding officer is still unable to make a decision in that, then they would actually call upon the parties to actually present and do make arguments in court. Yes, so, but the main reason for an application proceeding is just to be able to make a decision on paper with the affidavits that are in front of the magistrate without having your legal practitioners to actually make submissions. But then certain instances, a magistrate, the presiding officer, might request for you to actually make an argument. So that's basically it when it comes to action proceedings and application proceedings. It's easier to just on that aspect. So the same process just happens the same in relation to your magistrate courts and also your high courts proceedings as well. So just the only thing that's different is the rule number. So if you just understand the rule for magistrate court, which rule applies, and for high court which rule applies, that will be fine. So in case they throw a question on that, you'll be able to understand, once you understand this distinction, is this an application, or is this an action proceeding? So you check the question. The question will give you a guide, is that, okay, this is what needs to happen. Oh, so they want you to defend the matter, so then you understand, oh, okay, when they say they want you to defend the matter, so it's an action proceeding. Oh, they want you to oppose this. Oh, okay, then it's an application. Depending on how the question is phrased, it would give you an idea as to what you need to deal with and what is going on in this matter. Yes, and you also have your urgent applications that do come, and also your interlocutory applications that you would also have in a civil, in an action proceeding. Where even though it's not an application, it's an action. You do get instances where you get your interlocutory applications, where then in this instance you will have for example, you need an urgent interdict, that you need a court to actually make a decision. You can't wait till the final till the ending or to the finalization of the matter. So then you'll make an application, urgent application, for the court to make an interim order as to that particular matter. So then these are called interlocutory applications. These applications that are happening during the proceedings of an action proceeding, and it hasn't reached its finalization. You get where sometimes where you get you make an application where you want to compel the other party to actually produce evidence, those where the court would actually set that matter down, hear that application before it can actually proceed with the actual trial, with the actual matter in the action proceeding. So yes, so I guess with this, it could get you there. It could get you to where you'd like to be. Also, just do subscribe if you want more, and if you want me to go a bit more into the personal injury claims, for example, your motor vehicle claims, your divorce matters, they will be also linked into the matrimonial property. So if you want me to also just touch a bit on RAF, because they do ask about RAF in the exam, just let me know in the comment section. I can just give you also just tips. So this is on a section for civil procedure. Then you would actually probably come out with the 50 there. So if you want me to help you with the 50 with the motor RAF, then let me know. I will also just have like a small chatanyanya with you guys. And also, so it's usually civil or criminal procedure. If you want me to touch on that as well, just let me know so I can do it in quarters like this, so it doesn't be so long. And then and then I'll probably also just do the other papers as well, just so that it gives you a roundabout what to expect. So do subscribe, guys. This page is it's not for board exams, but I just decided, why not, since I am kind of like I'm doing something in relation to court procedure right now. So I was like, oh, okay, let me just share with you guys, and take it or don't take it. Like I said, I'm just thinking of it at the top of my head, but if you want me to get into more detail, I can actually go into the others, and then just you can. I think also when you do ask questions, that's when I will know as to you want more details into things. But like I said, we're just trying to get 50, just trying to pass, because if you pass now, then you don't have to write 5 papers next year. So yeah, this is from me, Miss Veg. Love you guys. Good luck for your board exams.